Chapter 2. Federal Judicial Power under Article 3. The federal judicial power is defined by Article 3 of the Constitution. Section 1 of Article 3 states that the judicial power of the United States is vested in one Supreme Court and other inferior courts that may be established by Congress. The federal court system is comprised of the Supreme Court as well as district courts and circuit courts. The district courts are where most federal lawsuits are originally filed. Any district court case that is appealed goes to the circuit courts, and any case appealed from the circuit courts will go to the Supreme Court. The Supreme Court will review a case on appeal when it grants a writ of certiorari. When a litigant loses in a federal court of appeals or in the highest court of a state, they may file a petition for a writ of certiorari, which is a document asking the Supreme Court to review the case. If the court grants certiorari, they will then hear the case. Let's move on. Under Article 3 of the Constitution, federal courts are only allowed to hear certain types of cases. In other words, federal courts have subject matter jurisdiction only over enumerated cases and controversies that are explicitly set out in Section 2 of Article 3. These Article 3 cases and controversies will be discussed in detail in the following chapters. Moving on, Section 2 of Article 3 also lists the types of cases over which the Supreme Court itself has original jurisdiction and appellate jurisdiction. Original jurisdiction means that a court can hear a case for the first time. Recall that the federal district courts, where federal lawsuits are initially filed, are the federal courts of original jurisdiction. But under Article 3, the Supreme Court also has original jurisdiction over a select few cases. Article 3 states that the Supreme Court has original jurisdiction over all cases affecting ambassadors, other public ministers and consuls, and cases in which a state is a party. Note that although the Constitution gives the Supreme Court original jurisdiction over these types of cases, the Supreme Court has declared that it may exercise discretion over whether to hear original cases. Today, it is extremely rare for the Supreme Court to hear an original case, and will typically only do so for a dispute between two or more states. Article 3 also establishes the appellate jurisdiction of the Supreme Court. Appellate jurisdiction means that a court can review a prior judicial decision from an inferior court. The Supreme Court has appellate jurisdiction over all Article 3 cases and controversies. However, note that Congress has the power to regulate the Supreme Court's appellate jurisdiction and may place limits on what cases can be appealed to the Supreme Court. In this chapter, we discussed the basic principles of the judicial branch under Article 3 of the Constitution. We learned that Article 3 vests the judicial power of the United States in the federal courts, with the Supreme Court as the nation's highest court. We learned that federal courts have the power to hear only certain cases and controversies listed in Article 3. And we also discussed the original and appellate jurisdiction of the Supreme Court. In the next chapter, we will discuss judicial review and look at the landmark Supreme Court case from which it came, Marbury v. Madison.